I wanted to include this presentation in the Divorce Depot podcast, even though it's very different from any of my other podcast episodes. In this episode, David and I are presenting online. You can see we have some difficulties with it at the Florida Supreme Court's Dispute Resolution Center's annual conference in 2025. And what we're talking about is how mediators can move their practices to do what it is that we have done for right now, it's the past 20 years with a friendly divorce. So if you are a mediator who would like to move your practice into mediating pro se pre-suit divorces, you may find this episode very informative. And I hope you enjoy it. Don't hesitate. If you have questions, feel free to reach out to me. Anyway, my little cheat sheet with what I wanted to say in the intro is not here, but maybe he has it somewhere. Nope, that's not it. Anyway, if you would put in the chat how many years you're mediating, that might be helpful for everybody to see how long you've been around. And if you would put in the chat what city you're coming from, that would also be somewhat interesting. If you have, we're not really used to this format, where every time.
Do we want to tell them who we are?
We wanted to tell them who we are. Tell them who we are.
Hi, I'm David Spofford, and this is my wife and partner, Elinor Robin, and we've been doing a friendly divorce forever.
It feels like forever, but in reality, it's only about 18 and a half years. And about 12-ish so years, we did that in South Florida, mostly in Boca Raton. For the last 15 years, we've been doing it in Gainesville. And I know that those years don't add up, but that's because for a long time there was overlap that we back and forth. We were the Florida Turnpike's best customers, going back and forth between the two cities. And when we decided to leave South Florida and come to Gainesville full time, we really didn't think we could have a full-time practice up here because the population here is so much smaller. Gainesville is really a city of 150,000 people, surrounded by farmland and very small towns. And we didn't think that there would be there's not, of course, the same kind of population in South Florida where you're looking at a stretch of, 8 million or so people. But sure enough, we have been able to recreate our practice here, and we are as busy here as we were in South Florida. So the first thing I want to tell you is that there's definitely a market for this service. And if you think that this service, if this makes you feel uncomfortable, don't do it. This is not for everyone. This has worked for us. We were not the first people to do this. Others did it before us, especially a man in Fort Lauderdale. I will give him he's also unfortunately passed away. His name was Jerry Deutsch, and he started doing this in the mid-'80s, and it worked for him until he was very, very elderly. And it has worked for us because I sort of would say that we are a lawyer, that's David, who doesn't want to practice law. And I'm licensed as a marriage and family therapist and mental health counselor. And I certainly don't want to do that. So we have found a niche, and this works for us. And we believe in the work that we do so much. We see our clients benefit so much from this process, and we know, and they know, what their alternative might have been, that this sort of keeps us going, even though we are both of the age where maybe it's time to retire, but I don't have the heart to turn people away when they keep calling. And I don't think we've done any advertising in the true sense of the word in the last 17 years. Certainly, we never did any advertising up here in Gainesville, and the phone just keeps ringing. So people do want this. What they want is a one-stop divorce process that will get them from start to finish. So I want to start off by showing you a little, my first thing and I'm going to watch the time carefully. So the first thing I want to show you is, let's show them the little drawing.
Okay, so
Is people who want to get a divorce have 4 options. And the way things work is basically every option ends in mediation or some form of negotiation. Very, very few people end up going to trial. Sometimes the really rich who, what's it to them to spend $250,000 on a divorce? They don't care. Sometimes they will go to trial. And sometimes the very poor will end up going to trial because they're not paying legal fees. It's some organization like Legal Aid, or up here we call it Three Rivers Legal, who's providing them that service, and they will end up going to trial. But about 95% of the divorces filed never go to trial. And everything is kind of settled in mediation. We're looking here for my little chart, and we're not seeing it, even though we had this whole thing set up in advance. So I'm going to talk, and if he finds it, he finds. If he's able, he's able. And so it was on my desktop is where it was. Okay, he'll find it. So people have 4 options when they are getting divorced. First of all, they can have a do-it-yourself divorce. And this works for people in general who have no children. They may have, so which means that it's likely that they're going to have no ongoing relationship. And often they have no real estate. So those questions of real estate really don't come into play. And what happens is, he's got it. I think everybody should be able to see it.
Well, I have to share it.
You have to share it. Okay, not yet. So there is a do-it-yourself divorce. He's going to share this, my little drawing, in a minute. And people can get all the forms that they need for a do-it-yourself divorce on the Supreme Court's website, or they can buy a packet at the courthouse, which is reasonably priced. They're basically just charging for, the photocopies, and they can fill out stuff online, and they can file it themselves and go in front of a judge for an uncontested divorce. If they don't own real estate and they weren't going to share retirement accounts, then I think is it showing now? Somebody say yes. Somebody who, it says, we see that it's sharing.
Yeah, it's right here.
It's right here. I hope everybody can see it. I know this isn't Jeremy, but whoever is here with us, can you just tell us that you see it, our drawing? Okay, all right. So you see on the left here is the do-it-yourself divorce. And so they go to the courthouse, they buy the forms. If they screwed something else up, no one's watching?
Right. Hopefully someone will watch this in the future.
No, we should be live.
We are live.
Okay, we're live. So we are alive. So we think we're live. If they screwed something up that's obvious to the pro se case manager, she will send them to mediation in the courthouse with a court annexed mediator if they earn under $100,000 a year. And then they'll go to mediation. Hopefully the mediator fixes everything for them. The pro se case manager will fix the forms. Anything that they screwed up, she'll show them what to fix. And then they get divorced. This is like going in a bus. Because in a bus, it's public, it's crowded, you're not getting really individualized attention, but it works if you have a short trip and not a lot of baggage, right? Then these other two ones over here, this is a traditional attorney-driven divorce. And in that case, both sides hire attorneys. Sometimes somebody will call me and they'll tell me that their spouse has hired an attorney, but they don't want to hire an attorney. And I'm like, no, you must hire an attorney. If your spouse has an attorney, you must hire an attorney or you're going to not do well. And so both sides hire an attorney. The attorneys figure out if it's to their client's advantage to file or not. And typically the attorney who it's to their client's advantage to file will file the divorce. The other spouse gets served. And then there's a process of discovery and depositions. And after the attorneys have learned all the information there is to learn, they go to mediation and they settle it in mediation. Typically, this is a lengthy mediation, a one-session, typically one-session, long mediation. In the end, they are divorced. And that is like hiring either two taxi cabs or two limousines. Both drivers are the lawyers, and the lawyers are driving in, of course, different directions with different agendas. But in the end, you get divorced anyway. Now, here is collaborative divorce. And collaborative divorce, both sides, again, hire, they retain collaborative attorneys. The collaborative attorneys have special training, and this one kind of everybody gets in one van together. The two collaborative attorneys, the spouses, and they'll hire usually one financial neutral. They will hire a facilitator or mental health facilitator. If there's a need for all sorts of other experts, typically they'll only hire one. So let's say they need a real estate appraiser, or they need a child psychologist or a vocational rehab expert. Instead of over here where they're each hiring their own, who are going to be dueling experts, here they're just hiring one, and they're going to listen to what that person says, and they're going to abide by what that person says. And then there's going to be a series of meetings. And after the series of meetings, hopefully they agree, and then they file the divorce. And then they're divorced. But on the chance that they don't agree, then they have to start all over again, only this time, not with collaborative attorneys, but with traditional attorneys. My one issue with this process, because I do like the idea of only one expert, but my one issue is often the spouse who is eager, if there is one spouse who is eager and another spouse who is resistant, often the eager spouse will basically chew off their foot or cut off their foot after all these meetings because they just can't stand it anymore. And so the eager spouse is at a disadvantage here. Okay. Were you going to say something?
No.
No. Okay. Next is what we do. We call our business a friendly divorce, but in reality, what we are is we do pre-suit. So nobody's filed anything. Pre-suit, pro se, they have not retained attorneys. Now, we do encourage them to consult with attorneys and pay an attorney hourly. But if they have retained an attorney, this process is no longer an option for them. So here what we do is we have a mediation. Then we gather, at this first session, we're gathering information for what their marital settlement agreement is going to say. So we're figuring out how are they going to handle their children, their assets, their debts, and any money that's going to change hands between them subsequent to the divorce. Then we have a second mediation session where we read them the agreement and we fix the agreement so that it's an accurate reflection of what they want, because now they're looking at it on paper. And at that time, they do have the option here to consult with attorneys. After that, they come back. I don't have it here, but they do come back one more time when they sign the agreement as well as all the other forms. And this is the part that was previously controversial, but I believe it's no longer controversial because according to the rules revision that was in, was it
2024.
2024, that's rule 10.340E4, the mediator can prepare the forms, and this is in the committee note, the forms and notarize all of their documents. And so sometimes we hold these 2 sessions on Zoom, sometimes we don't, we hold them live, we'll do whatever the parties want. But that 3rd session is always live because that's when they sign off on everything. And then either we or the parties will take it over to the courthouse and file it, and then they get divorced. And if for some reason it doesn't work, now they have to try something else. And what this one is this is sort of like they're renting a car. And they're renting a car and they're getting well, here it says a map because I made this a long time ago, but what they're really getting is a GPS. So we're kind of telling them, like, you could go here, turn there, or do whatever you want, go another way. These are the options. We're showing them, maybe a map is more accurate. We're showing them that there are options, but they have to drive that car themselves. We're not doing it for them. Okay, so that is the first learning objective we're here to talk about.
So stop sharing.
Let's stop sharing. And now, okay, can we make this bigger? No. Okay.
Apparently not.
No, apparently not. So, all right, we got that. The second learning objective that we want to talk about is, so this really worked for us because, as you can tell, we have very different personalities. And where his strengths are my weaknesses. Where my strengths are his weaknesses, and this worked for us. But on our website, afriendlydivorce.com, we have other mediators who provide a similar service, and none of them work as a 2-person team. They all work on their own. So we know at this point in our lives, if one of us were to go off to the big mediation pool in the sky, the other one basically doesn't want to do this business on their own. We need each other to do it. It's for us, this is what works. It may work for somebody else. It may not. I mean, we like the idea that we're a male-female team and a legal background and a mental health background. But, there are people doing this all over the state, and I'm not aware of anybody else doing it the same way exactly that we do it. Yeah. So the next one is, so why I'm telling you this is because we know that there's a broad spectrum of knowledge that you have to be able to do this work. And if you have gaps in your knowledge, you want to find ways to fill them in before you start doing people's divorce, because we know that when you have the power to do good, and there is tremendous power here to do good and earn a good living, but you also have the power to do harm. So you can really screw people up if you screw up their divorce. And so it's really important that you have this broad base of knowledge. And we know that one of the things that makes family law unique is that the family lawyer and the family mediator have to have such a broad spectrum of knowledge. They have to know about everything from, parenting practices to retirement accounts and insurance policies and mortgages. They have to have an understanding.
Right.
I think it's really important that we know what we don't know, and then we send people elsewhere to try to do their own research and talk to somebody else who can give them the advice that they need, because they could walk in with anything, needing a special needs trust for a disabled child. We don't know how to do that, and we're not going to do that, certainly. But there are so many things they could need. We just want to send them elsewhere to do it. All right. So I have a list here, unless somebody wants to. If you know that you're weak in one area, where are some places that you could go to get the education you need to continue and do this process? So I'll give you a minute to put it in the chat, but in the meantime, I'll give you my answers. So first of all, here, you could tell them the answers. Here's the answers.
So the Florida Bar offers classes, paralegal classes. You can talk to self-help people at the courthouse. Every clerk's office has a self-help office that is there to help folks who many people do this on their own, and a lot of times the ones who can't afford or whatever will just do it themselves and muddle their way through. And so hopefully most of those people don't need as much help. You can attend the class. There's a required parenting class that everybody that has minor children has to attend. And there are Florida Supreme Court approved family forms that you can read over, and you can read over the instructions to those. You can take a look at Chapter 61, which is in the Florida statutes, which is all of the divorce information.
And nobody, it seems, has given us another answer.
Another option, yes.
No. But we gave some good answers.
Sure. Well, let's move on to looking at actions that mediators can take to be successful while protecting themselves and the parties.
Yes. So, because that's important, that we know that you have to protect yourself and the parties and the, whole process of divorce. So the first one we have is that you have to send out an extensive letter of engagement. And that letter of engagement is going to include everything that you would normally say in your opening statement, plus. So in our letter of engagement, we certainly tell them the date, the time of the mediation session, and the location, either it be on Zoom or in our office. We have an office here in Gainesville. We also do use space in Jacksonville. If anybody is in Jacksonville at the Jax Mediation Center, they are a wonderful facility and they rent conference rooms by the hour. We explain the process in our letter of engagement, how many sessions or how many hours, what about a possible separate session. We tell them about the parenting class, the required parenting class. If they have children, they have to take that class. We definitely talk about confidentiality, confidential according to Chapter 44, and we explain our fees. This is a really important one because in our opening statement, we're not talking about fees, but so the fees are outlined before they even walk into our office. And that's to send out, so create a really good letter of engagement.
And then second, we have a form that is quite detailed that allows us to just follow along and fill in all the information that we need from them in order to be able to prepare the marital settlement agreement, a parenting plan, time sharing schedule, and so forth. And it just goes right along. And our form follows the peace outline, which is parenting, equitable distribution, assets and debts.
Alimony.
I was thinking assets and alimony, child support, and everything else.
If somebody took my class years ago when I was teaching the family class, or they have my book, the training manual, which is available on Amazon. On page 97, there's an example of our intake form that we sit there with at the first session.
Right.
Okay.
And we use a multi-session format. We meet with them initially and gather most of the information. And in most cases, the folks who come to us are wanting to do this, and they find themselves coming into agreement. And of course, we're mediators, so we help them come to that agreement over any rough spots. And typically by the end of the first session, they've got a pretty good idea of what the agreement is. There may be some details missing. They may have some homework to. And a couple, 3 weeks later, usually we don't get them a draft of their agreements until 2 weeks from the meeting, and then we'd like to not meet with them for another week after that. So our second session with them, where we will read through the agreement, occurs 3 or, depending on their timing, more time from the first meeting. And by the end of that meeting, we've got it pretty well down.
Okay, so next, you of course must avoid the unlicensed practice of law. And we find that if we provide information versus opinion or advice, that certainly is a step in the right direction. And some things that are information are like the difference between a promissory note and a deed. Sometimes people think if I just get her off the deed, which is pretty easy, then the house is all mine. Well, no. Or they think if I just go off the deed, then I'm not responsible for the promissory note, but that's not the way it works. So often we're explaining to people what a promissory note is, what a deed is, and we're telling them the difference. Another example, which people often don't understand, is in any insurance policy, there's an owner, a beneficiary, and an insured. And if you're the owner, you control who the beneficiary is. So if you think that your former spouse is going to be the owner and they're going to keep you on as the beneficiary, you're probably hallucinating. Or maybe you're hallucinating,
Well,
but
there's a good chance that especially after your ex meets someone else and falls madly in love with them, that they're going to change the beneficiary to that person and leave you out.
So the only way really to ensure, because people move and stuff like that, and then, the insurance company can't find them, the only way to ensure that you are going to be the beneficiary is if you are the owner. And we explain to them how insurance policies work. We don't tell them what to do. We just explain it to both of them with them both there. And that's an interesting point, because if you're explaining something to somebody and you have to explain it to them without their spouse there, then that might be not just information. Because if it's information, we can give it to them both and let them figure out what they want to do. Okay. All right. The next one we have is.
So one of the things we really, really like to do, and we encourage, if you're going to do this, for you to do it as well, is while you got them both sitting there at the second meeting, read through the agreement word for word. Fix anything that needs fixing. We can work out with them anything that needs to be still needs to be figured out, and find any errors that we made. We do make errors a little bit here and there. And hopefully not in the final, but
Go ahead. No.
Anyway, do it. And that way we know that it's in good shape. And then next.
I don't understand why we see nothing in the chat. Absolutely nothing. So I don't know. I think we may be talking to ourselves.
I think that, this may be a very unpopular session for the live.
No, I know it's not true. I know there's somebody is out there. I have friends. They're there. Okay, so the next one we have is don't overstep your role. Certainly we do not prepare. Oh, somebody said something. Thank you. Okay.
No, that's
no. She's not there? Okay.
Oh, I don't know what that was.
I think we're on the wrong chat is what the problem is. Anyway, I don't know. We better not touch anything or we'll get disconnected. Don't overstep your role. Do not prepare quitclaim deeds for people. That's practicing law. They can do it themselves or they can hire a real estate lawyer or anybody, just not you, to prepare their quitclaim deeds. And certainly you are not going to prepare quadros, qualified domestic relations orders for people either. Okay, you're talking about the next one.
Okay, so there are a number of people around who will prepare quadros. We have found that Matt Lundy understands what we do, and he will prepare the quadro, and a quadro is a qualified domestic relations order and is needed to divide a qualified retirement plan such as a 401k or a 403b between the spouses in divorce. So we refer to Matt Lundy, and also he files it electronically. We don't have to be involved. So once we file the case on behalf of the clients, basically we're just the courier to the courthouse. Once everything has been signed, we will file it. And once that's done, they contact Matt Lundy or whoever they choose to prepare the quadro, and that person will file it electronically, and we are not involved with the quadro. As far as calculating child support, we use family law software. In the past, we have used other programs, but for quite some years now, we have been using family law software and are very happy with it for the calculations. And Elinor, you're the next item.
Joni says, make sure you're in group chat, not direct chat. Maybe that's our problem.
I have no idea.
Thank you, Joni. I knew you were there. Okay. Okay. Turn away inappropriate clients. If someone is gonna not be able, see, our clients honestly are easier to deal with than the people who walk through a lawyer's office. They really are. I tell our clients all the time that they should pat themselves on the back because a lot of people just do not have the emotional maturity necessary to sit down and negotiate these plans. On the flip side, I think a lot of people do have the emotional maturity necessary to negotiate these plans, and they just don't know that this option exists for them. So people, if you talk to somebody on the phone and it's going to be clear that they're going to be a difficult client, turn them away. Everybody's idea of difficult is a little different. I mean, for me, everybody going through divorce is, they say that people in family court are, oh, we just got bigger on the thing. But
no, this is not.
Oh, we look frozen. People in family court are good people on their worst behavior, and in criminal court, they're bad people on their best behavior.
Okay.
So, now we see all the questions. Okay, we'll save time at the end to answer some questions. Oh, somebody said this is an important one. Can we electronically file the divorce packet online through the e-court system? Not the attorney, and you're not the mediator. Because the mediator doesn't file forms, the mediator only files the marital settlement agreement. So no, we do not use the electronic system. Now, the parties could take paper versions or electronic versions and file it themselves through the electronic system. But if you're doing this particular work, no, you cannot file electronically, in my opinion. Everybody does what they want to do. I can't tell anybody what to do, but we would not do that.
Well, the last time I looked at it, it appeared that only the parties could do it because we are not in the case.
Yeah.
We have no role in the case.
Yeah. When we first moved to Gainesville, I figured, oh, there's no way we can earn a living doing this up here. So the woman who then ran the court program was very nice and gave me a contract doing, court annexed mediations as a contractor. And then I did file my agreements through the portal, but I do not do that anymore because now not only are we filing agreements, but we're also filing the packet. All right, but that's a very important question that we didn't even touch on. So thank you.
And here's a comment about the life insurance and the redesignation. You must. One thing that we make a point of telling people is that if they want to maintain the spouse as a beneficiary of their life insurance policy after the divorce, then they must redesignate the spouse as the beneficiary after the divorce.
Okay, so anyway, the one I was up to was turn away inappropriate clients. If it looks like somebody is going to be having meltdowns, they're probably not a good client for you. If there's serious allegations of domestic violence, they're not a good client for you. If somebody is totally in the dark and they don't know anything about the money and they admit that they don't know anything about money, they're not a good client. They need somebody to do some, discovery or whatever it is. Okay. So turn them away. We can't be all things to all people. We do not take any. Oh, see, they gave us answers.
Right.
Like they gave us answers on how you can learn more. Yes, so the answers are in there. There's information there. Okay, so we do not accept any client who has already filed. We learned our lesson. We used to, but we don't anymore because that becomes a big pain in the neck. So,
well, not only that, how do you undo what they did? And I feel like that's getting too close to practicing law. I don't want to mess with fixing somebody's paperwork. I mean, a lot of times we would file a amended parenting plan in place of the parenting plan that they had filed. And I just don't want to go there anymore. We haven't done that in like 10 years.
All right, you're doing this one.
All right. Okay. So when it comes to filling out the forms, one thing that's important is we sell a package deal. So they are buying the mediation that results in a marital settlement, a parenting plan, and a time-sharing schedule, as well as filled out forms. They're buying that all as a package. We're not selling them anything after they first hire us. And we make a point because it says that when you're a form preparer, especially if you're not a lawyer, or even if you are a lawyer, don't alter the forms. We're not allowed as form filler outers to alter forms. We don't alter the forms, and we fill in their information in the forms. And unfortunately, some of the programs that will create these forms automatically for you, they'll change the forms. And so I don't use them. I have a program called Pythagoras that will just do search and replace on a Word document. And I have all my forms set up to do search and replace and put the client's information into the Florida Supreme Court approved forms.
Okay. The next one we have is
write agreements that reflect the parties' agreement. So my goal in writing their agreement is to lay out their agreement. And what that means is anything that a lawyer might normally put in, like boilerplate, severability, the headings don't count. There's a standard provision that a lot of lawyers include in an MSA regarding inheritance and those types of things. We don't include that unless the client specifically asks for it, and they won't ask for it unless they've gone and talked to a lawyer and their lawyer says, oh, you ought to do that. I simply draft the agreement.
Okay, so, and he drafts the agreement, but then in between sessions, we don't change the agreement, because if we did, they would be calling us 3 times a day telling us to change the agreement. So we tell them in the opening statement that we're not going to change the agreement until we have them both back here together so that we can ask them what if questions. And that really does work the best, because changing the agreement without having the two of them face to face, whether it be on Zoom or in person, it's a disaster. So don't change, tell them we're going to change the agreement when we get you here together, but we're not going to change it in between sessions. Now, sometimes though, they have to fill something in, and we will fill something in between sessions. Like, let's say they want to fill in later what the cost was of the children's health insurance, or you know, what kind of car they had, or we'll fill things in, but we won't change the agreement. And we do see clients on Zoom, but lately more and more people have been wanting to come back post-pandemic into the office. So not only, if you want to do this work, not only should you know how to use Zoom, but it would be good if you had a physical location. And for years in Gainesville, we just rented a conference room from one of our friends, but now we have recently rented a space in his building. And in Jacksonville, we do use the Jax Mediation Center. Okay, and this one.
Okay. So our last meeting with clients is almost always in person, because that's when they sign. Now, we do handle situations where one of the spouses is in another state, for example, and we will mail the documents. We really like to avoid that. And when I do that, I print out all the documents and I put yellow Post-it notes with notes saying sign here, initial here, notarize. We recently had somebody notarize, and the notary did not put when their commission expired, so we had to have that redone. We really like to have the people together with us in person at the final session, even if all the other sessions have been on Zoom, so that we can walk them through signing everything and get it correct.
Go to the 15.
Oh, I like your next one. It says, ask questions, ask questions.
I was going to skip over it because I figured that's just basic mediation. You just have to keep asking them questions, because
right. Don't tell them anything. Ask them questions.
And they don't know. Like, a lot of times people call me up and they say, oh, we resolved everything. Oh, you did? And then I can start asking them questions. Oh, no, we didn't even think of that. So you just have to keep asking them questions. And that, I mean, that's I think that the best trait a mediator could have maybe is natural curiosity. Ask them questions. Okay, now go.
All right. So when dealing with an unfamiliar county, you can go to the clerk of the court of that county, and frequently they will have information about any special forms that they require, any special procedures. It's good to know, for example, in Duval County, that they will only accept parenting classes from 3 particular providers. Most counties will allow you to go to any parenting class online or in person, but not Duval County. You can call the pro se case manager when dealing with an unfamiliar county. In some counties, they'll talk to you and be very helpful. That's certainly true in Gainesville and in Alachua County.
It's not true in Broward. And
I was just about to say Broward.
You can tell them we said that. We have found Broward to be extremely unhelpful.
And we're imagining it hasn't changed in the since we haven't done anything in Broward in probably 8-10 years.
Yeah, but I hear that it's the same.
Okay. Make sure that you're set up to take credit cards. We use Square, and obviously there's other places.
If you have my manual on page 213, there's a sample time sharing arrangement.
Right. Okay.
All right. This one, encourage the parties to investigate things like pension benefits. If they have but I want to go back to Josette had a question that I think is.
Yes, that's why I was leaving it on there.
All right. Encourage the parties to investigate things like pension benefits. Like, for instance, if a spouse is going to take half of their spouse's Florida retirement system, and then that spouse dies, the pension that they're receiving dies along with the spouse. People should know this. And I'm not going to tell them how things work necessarily, because things change all the time. So I want them to go and investigate with the administrator of their retirement benefits what the deal is. If you're in COBRA at the time of a divorce, I want them to call the employer and find out how many months can you get COBRA for. So we're always encouraging them to do their own investigation. But Josette says, I know 2 people who went to a mediator for divorce, and the feedback was they need to hire an attorney. Is this a normal situation? Well, no, they don't need to hire an attorney. They will need to hire 2 attorneys, because one attorney cannot represent both of them. And this is mediator who doesn't understand that there is another way to get divorced other than hiring attorneys. There's 4, I'm going back to number 1. There's 4 ways to get divorced. One way is you hire attorneys. And a lot of mediators, especially attorney mediators, their market is parties who are represented. And we know that in Florida, in general, attorneys will only choose a mediator who not only is an attorney, but practiced family law in Florida. That's that market. And so if you're not an attorney, or you're an attorney, but you just moved here from New Jersey, or you're an attorney, but you never practiced family law, the chances of attorneys choosing you is very slim. Of course, my pal Deborah Bayless is an exception, but she's one exception out of thousands. I don't know that many mediators, if any, other than her, who were able to bridge both marketplaces, the unrepresented and the represented. And I'll tell you something, sometimes the attorneys also think that the only people whose divorce we can do are poor. But here we had clients who were the wealthiest of anyone we have ever seen in our 18 or 19 years of doing this. And they were really, really rich.
I don't. Oh, you speculated that they had a lot more than they told us they had.
Well,
But
because
they had at least 30 million. I don't.
oh, they had, but some things we didn't know the value of. Like we don't know the value of this trust or that trust. It didn't matter to them. So I was speculating that their net worth was about $500 million, but that's irrelevant. And they were not local to Gainesville. I'm not telling you.
And that wasn't unusual. I mean,
Yes.
over the years, we've had a number of folks who have been well over 10 million, and frequently we see folks whose marital estate is a couple $1,000,000.
So I think, Josette, the answer is that mediator just is leaving money on the table. He or she just doesn't understand that there's another market out there. Okay. And so we use a fixed price model. And the fixed price model, our pricing is all spelled out on the website. What we're selling people a package. Okay. All right. So we're selling them a package. It's all on the website. You do this one. Oh, we said this one already. Okay. So, but sometimes somebody calls and clearly they cannot afford our service, or they earn under $100,000. And in that case, I'm always sending them to the pro se case manager. Now, I will tell you that in Alachua County, we have a great pro se case manager. The one before her was also an amazing person. And I just sent people there. People are so appreciative that I'm giving them the answer for what they need to do. So if they can't afford us, we just send them elsewhere. Sometimes, especially with time sharing, people will say, oh, we don't need to put that in writing. Oh, we'll just work it out. Oh, well, it'll all be fine. And it will be fine as long as they get along. But as soon as one of them is in a relationship with somebody else, often that's when the proverbial poop hits the fan. And that's when, I say worse than that. And that's when things start falling. Them to put everything in writing that they possibly can. You do this one.
Oh, figure out how you're going to get paid. The way we do it is we have a fixed fee, and we collect half of the fee at the first session and half of the fee at the second session. Occasionally, people will be financially strapped, and we will take payments, and thankfully, that doesn't happen very often.
I will tell you that in the 18 and a half years we're doing this, he doesn't even remember it, but there was one time when we did get a bad check, and it was, well, we were still in South Florida, so it's like a really long time ago, and that's the only time we ever got stiffed. Interestingly, when I did cases where the parties were represented, then I also got stiffed, and I remember that.
That's true. Yes, I remember that specifically. That was a friend of yours, and she went in as a mediator and never got paid because he didn't get paid.
Yeah. So we'll leave that nameless. That person will remain nameless. Okay. So. Oh, here's an important one. Sometimes clients want to use their marital settlement agreement as a faux will, as like a make-believe will, and we have to tell them, no, you can't do that. You need to go talk to wills, estates, and trust lawyer, because you can't use your marital settlement agreement as a will. And now?
So a lot of times, divorcing spouses will have been in business together, and they'll want to continue being in business together. It's really not a good idea to try to write their ongoing joint venture or business agreement into the marital settlement agreement. And I really don't want to get into that anyway, because I see that as practicing law. So we will refer them and say, you really need to go to a business lawyer and have the lawyer write something up. They don't always do that. They decide they'll just continue to go on as they have. But it really doesn't belong in the marital settlement agreement.
I don't know if this was before or after I said this, but Dawn asks, I have a filing specifically for mediators with the Florida e-filing portal as mediators. Yes, if all you're doing is preparing a written agreement for them and a parenting plan, you can definitely file that on the portal. But if you're giving them a package, a one-stop divorce package, and that includes the petition, the answer, a waiver of filing financial affidavits, etc., then do not use the portal, because the mediator does not do those things. A document preparer does those things.
And I don't believe there's anything on the portal for a document preparer.
There is not.
To be a party to the case.
No.
Not a party, but.
No. Okay, you get the next. Oh, no, I get the next one. So years ago, David was told by somebody at the bar that he should refer to himself as JD and not as ESK, and when he's providing this service. And she said that calling yourself ESK can be confusing to the parties. And so everybody on our website, even though many of them are Florida attorneys, we call everybody JD. And Gail asks, as a mediator, can I also be the notary without charging any additional fees associated with this service? Yes, you can look and see that in the
2024 revisions to the mediator rules. I think it's 340E.
10.340E something.
E3, I think it is.
But yes, I do act as the notary on everything that we file. Okay. This is maybe the most important one. Do not, and this one I'm like really telling you, I can't tell you what to do whatever you want, but this one, listen to me. Do not take any case where the parties have retained lawyers. This is what they're going to tell you. They'll tell you that they want to do this without the lawyers because they're paying the lawyers. They're sick of paying the lawyers. The lawyers aren't doing anything, yada, yada, yada. Doesn't matter. Tell them no. The lawyers must withdraw before you can provide this service. This is to protect you, it's to protect the lawyers, and it's to protect the parties. They're going to tell it to you anyway. I wish I had a nickel for every time somebody calls me up and says, oh, now we want to have a friendly divorce. We're sick of paying the lawyers. No, do not take that case. Do not. Go ahead.
All right. Oh, and don't prepare forms for one side. Don't prepare forms until you know there's going to be a signed agreement. So there are two reasons why we don't send out the forms, the draft forms, with the first documents that we send out. One is that it can be very confusing, especially if there's children, because there's a stack of forms, and it detracts from the agreement and the parenting plan. And the other is that we don't know for sure that the agreement is going to get signed. Once you've had your second session and everybody is on the same page, and you've read through the agreement, you know the agreement's going to get signed, 99%, then send the forms.
Okay. All right. We have 3 minutes left for some questions, and I see a question that says, can an attorney enter the case post-mediation with appropriate conflict waivers? I'm not exactly sure what you mean, but attorneys can file a limited appearance. Duval County, sometimes people have to wait a really long time to get in front of a judge for a pro se divorce. So we do send people to an attorney there who is willing to take the case, and she files a limited appearance, she gets a hearing, and that's it, then they're divorced. So she just uses everything that we already filed. After we already filed everything, she just steps in. And you know, I don't remember what she charges, but let's say it's $800, something like that. It's if people are waiting for it, you know, and the county is, if you're in a county where they're slow, then that's often a good way for them to go. Oh, and Lizette, David is answering you now. And give us another question there on the thing. We have 2 minutes left. Do you have the parties complete the disclosure for non-lawyer? Yes, yes. Do we use DocuSign? No, we don't. We don't use DocuSign. Allowed to notarize. What manual? The manual is, for many years, I was in the training business until I couldn't stand, I just couldn't take repeating myself over and over again. But the
divorce can be filed in any county in Florida.
Yes.
If there's children, it's really best to file in the county where the children are.
Yes, but I will tell you that my friend is the attorney for the clerk of the court here, and I always tell her, you know, we file a lot of cases in Gainesville just because we know how easy it is to work with this court, that she should tell the clerk that they're doing something right, because we do file cases here, that where the parties didn't live here, and that also gives them an extra piece of protection. But I was answering another question and now I don't remember what it was. I was in the middle of some other thought. Oh, well, I don't remember. Anyway, it's 12:30. So you can find our fees on our website. They range $2,800 if you have no kids and $4,400 if you have kids. That's our fee.
Sessions are usually 3 hours.
The first session.
With children, without children, 2 hours.
Yes. And anyway, we're around. If you've been doing this work and you want to come on our website, call me. But first you have to learn what you're doing. So we have a lot of faith in the people who are on our website. So anyway, thank you all for being here. What manual? That was the question. So there was a manual. Ty Bordoni's program uses that manual, and Keith Grossman's training program, use that manual. The manual is on Amazon, and if you put in Elinor Robin Florida Mediation Training Manual, it probably comes up. So that it's just the manual from the actual certification program. But there's a lot of information in there that's relevant to this. Anyway, do we have anything else to say?
I don't know. I don't know if we've been cut off.
I don't know. It's 12:31, so we better say bye-bye. Say bye-bye.
Goodbye.
Bye. Bye. Bye.